My lords, my lady, I think you'll be relieved to hear that I've nearly finished. I apologise for encroaching into my learned friend's afternoon time. Can I move on to point 5 in the note?
Yes.
I can take this very, very quickly. We say that that point is supported by the approach of the majority in GM Eritrea. For that was a case where the immigration judge declined to make speculative findings about why NY left Eritrea, as is clear from paragraph 27 of the judgment of Lord Justice Buxton. Lord Justice Laws, in his judgment, was very clear that the appeal should not prosper on that basis. That's paragraph 57 of his judgment. In the interest of time, I'll just give you those references for your note rather than to take you to them. It's also an approach that was adopted by the Court of Appeal in BA Eritrea in paragraphs 24 and 25, following on from GM Eritrea. And that authority is in volume 2 at tab 11. The sixth point, we submit that the only case in which the fact finder may not, as a matter of law, treat the lie as decisive is where, apart from the lie, other evidence accepted by the fact finder shows that the claim for protection must, not might, succeed. And we say this flows again from the approach of the majority in GM Eritrea. Perhaps just take your lordships and ladyships back very quickly. It's volume 2, tab 17. And this point is summarised by my Lord Justice Dyson, as he then was, in paragraph 62 of his judgment, where he draws on two passages in the judgment of Lord Justice Laws. Lord Justice Laws says that where a case depends entirely on general evidence, it will only succeed if, fanciful exceptions apart, the claimant must have left illegally, whatever the facts, paragraph 52, and unless the possibility that the particular facts may make a difference is effectively excluded, paragraph 55. I agree. So those two formulations we submit are treated both by Lord Justice Laws and by Lord Justice Dyson, as he then was, as being equivalent. And one can see how those formulations work in practice if one looks at the end of paragraph 64 of the judgment of Lord Justice Dyson, as he then was. The last sentence, he refers to the evidence in that case, and he concludes by saying it was entirely possible that MY left Eritrea legally. So that's where we get proposition 6 from. And drawing the propositions together, we say that those 6 propositions set out in our note encapsulate the constraints which the law places on a fact finder's treatment of a relevant or potentially relevant lie. Where the fact finder decides on all the evidence to treat the lie as decisive, he has done so as a matter of his judgment. So whether he decides to adopt that approach is entirely a matter for his factual judgment. So it's open to a fact finder to decide on the facts of an individual case that a particular lie is not decisive and that the opponent has therefore satisfied him that he will be at real risk on return. But here we say the general evidence showed that it was possible that the respondent could get protection on his return. If the general evidence showed that it was possible for him to get protection on return, then it was open to the AIT, although they were not obliged to treat his lies about his contacts as relevant. The weight to be attached to that relevant evidence was a matter for the AIT, and they could ascribe either no weight to it or some weight to it. And when one looks at the reasoning of the AIT, we say that the approach they adopted to the lie is approach that was open to them. And on the basis of the reasoning of the court in GM Eritrea, the fact that it was statistically unlikely that protection would be available to the respondent is really neither here nor there. That may seem a harsh result, and the AIT were all too aware of that, as is clear from their determination. But the question for them, the question for the Court of Appeal, reviewing their decision, was not whether it was a harsh conclusion, but whether it was an unlawful decision. And we say it's clear that it was not. I had said that I was going to deal with a fifth building block, which is the decision of the Court of Appeal. I think I can take that very shortly, because I've made, as it were in passing, all the points about the decision of the Court of Appeal that I wanted to make. There's simply one further point I would like to make that I haven't already mentioned. So could I take your Lordships and Ladyship to the Court of Appeal decision again, please? It's at page... the passage I'd like to show you is at page 32 of the core volume. And this is a passage in which the Court of Appeal seek to make a distinction between GM Eritrea and this case. So the Court of Appeal's summary of the reasoning in GM Eritrea is this. Essentially, therefore, the court was in agreement that where an appellant tells lies, that may leave a tribunal with no evidence from which they can determine whether in a particular case he or she will face a real risk of persecution on return. However, this will only be in a case where, to use the language of Lord Justice laws, it knows nothing more than that they fall into a general class, or, as Lord Justice Dyson put it, the case depends entirely on general evidence. If there is evidence independently of the applicant's testimony relating to the particular situation of the applicant, so that the tribunal is not left simply with the general statistical evidence, then the tribunal must consider that evidence and reach such conclusion as they consider appropriate. Now, I'm so sorry. What the Court of Appeal are doing there is to say that there's a subset of cases where you don't have just the general evidence, you have some additional accepted facts about the appellant, and in that sort of case, i.e. the case that they were dealing with here, it's legitimate to adopt a different approach. We say that's an unnecessary distinction. The position, we say, is either on the basis of our broad submission that the fact finder is must take into account all relevant materials and give it the weight which he or she thinks is appropriate, or secondly, we say, the approach is that set out in what we've called our narrow submission, and there really is no necessity for there to be this third class to which the Court of Appeal refer. Those, as well as the points that I've made in passing about the Court of Appeal's decision, are all the points that I'd like to draw your attention to, and our overall submission based on those points is that it's plain that the Court of Appeal got matters wrong and interfered impermissibly with a factual assessment carried out properly and lawfully by the tribunal. Can I just deal finally with a point that my Lady Baroness Hale made to me this morning, and that's about whether the test in an Article 3 case is a different test from the test in a Refugee Convention case. I'm going to take this very shortly. Can I ask you to look at our printed case, because I think this is the shortest way of dealing with it, please. It's paragraphs 40 and 41. Now, the distinction I'd like to try and draw is a distinction between the method that a fact finder should adopt in relation to finding facts, either as regards a claim for protection under the Refugee Convention or as regards a claim for protection under the European Convention of Human Rights. And our submission is in relation to the method to be adopted in assessing such a claim, the approach is that set out in Karanakaran. It may well be that the test to be satisfied by a claimant under the European Convention on Human Rights is somewhat different from the test under the Refugee Convention. But that's not an issue that we need to explore in this case because it's accepted on the facts of this case that if the respondent were returned to Mogadishu and if he doesn't have protection available to him, then he would be at risk of Article 3 ill treatment. So I hope I can deal with the point in that way. May I just have a moment, please? Unless there are any further points on which I can assist, those are my submissions.
No, thank you very much. Ms. Ree, is there anything you wish to add? Thank you. Yes, Mr. Bell.
Well, look, can I start by a very short general commentary on my learned friend's formulation of her 2 points, just so that your Lordship and my Lady know where I stand in relation to those 2 points. Well, her first formulation is that the issue of Article 3 risk is a pure question of fact. And the second one is a narrow submission, which she described as a narrow submission about the weight to be attached to a lie. As to the first, we of course accept that the issue of whether or not there is a real risk on return is a question of fact for the tribunal. That was conclusively established by the House of Lords in the Algerian case, when I had submitted the contrary and lost. So I accept it and don't wish to go back on that. We don't see that that takes us very much further, though, because presumably the formulation can't be meant to exclude the possibility that in making findings of fact, the tribunal has misdirected itself. For example, it may have misdirected itself about the weight to be attached to the existence of the lie in the particular circumstances of the case. So calling it a question of fact can't prevent the Court of Appeal or this court from investigating whether or not the reasoning process of the tribunal is sustainable. As to B, I of course accept that there will be circumstances in which the fact that the appellant to an AIT has lied has probative weight. And the cases such as Lucas in the criminal field demonstrate that that is the case. But there are 2 important observations that I would wish to make immediately. First of all, in my submission, this is not a case where the AIT, in this case, did give probative weight to the lie. The Court of Appeal very carefully identified the fact that the approach of the tribunal to the lie was to say that it precluded the tribunal, from making the appropriate findings of fact. We say that was erroneous and is an error of law. We'll come back to the detail of that in due course. The second is that whilst I accept that the fact that there is a lie may have probative weight, one has, of course, to be extremely careful about the circumstances in which you give it probative weight and what it is said to prove. The Lucas direction itself makes it plain that people may lie in a criminal trial out of a variety of motives, and indeed directs the jury to be satisfied beyond reasonable doubt that the lie was to disguise the defendant's guilt. Now, in the context of the present case, of my learned friend's case, the lie has been relied on to make a positive finding, which I don't accept the tribunal may, but in my learned friend's case, it's being relied on to make a positive finding that my client did have, at the date of the tribunal hearing, contacts in Mogadishu. Now, I don't accept either that the tribunal made that finding, we'll come back to it in due course, or that if it did, it could rely on the lie it had identified to make that finding. I'll say without any great joy that there are a whole series of adverse findings of credibility against my client. And your lordships will look just at page 75 of the appendix. Your lordship will see towards the foot of the page, citation by the adjudicator in that case, by the immigration judge in that case, of the earlier decision in 2003. And your lordship will see in paragraph 28 that the adjudicator stated at the hearing the appellant was unable to confirm where his parents were born. His words were, "To be honest, I did not ask them." Then the adjudicator sets out more of that. And the very end of the passage says, I also do not find the appellant's evidence credible at all. I note the appellant trying to backtrack the fact that he's a member of the Isaac clan, but he's now been made aware that the Isaac clan does not suffer persecution. And the truth is that in the very complex history of Somalia and the position of majority and minority clans, the motivation for lies would change in a way which is incredibly difficult to predict over the 5 or 6 years that my client's case was going through the system.
Well, to say that the lie cannot be relied upon to found a positive finding is an assessment of or an evaluation of the facts of this case. It's not a proposition of law, as demonstrated by Lucas.
That I agree. Well, it's not an abstract proposition of law, but what Lucas demonstrates is that there will be some circumstances in which the lie is probative of guilt.
Yes.
If you make a finding that the motive behind the lie is to disguise the guilt.
Yes.
Equally, there will be situations in which it's not probative of guilt if you aren't convinced that that is the case beyond reasonable doubt, if you think, for example, it's done out of panic or whatever. Here, the structure of my learned friend's argument is that the tribunal did make a finding of current connections with Mogadishu. And I don't think they did. I submit they didn't. But in any event, they would have to identify a lie made for the motive of disguising current connections with Mogadishu. And they certainly don't do that. He was lying, in fact, in the past about where his parents came from. There was a major issue of whether he was could safely be returned to Somaliland, and therefore had a major motive for disguising his connections with Somaliland. None of this is very helpful material for pointing to any of the lies as a basis for a positive finding against the background of the general country evidence, which I'll come to in a moment. But he did have present connections with Mogadishu.
Well, is in effect what you're saying is that if they did make such a finding of fact on the basis of the lies, that was irrational.
Yes. Yes, my primary thing is for precisely that reason, precisely because I would be able to say that, it strengthens my submission, they didn't make any such finding. And that's the approach of the Court of Appeal. They stopped with at the point when they say, you are lying, we have not got the material to make the relevant findings.
I take your point that they didn't make any such, place any such reliance on the lie, but to say that it would have been irrational for them really puts us in the position of the tribunal, which we can't possibly do. How can we have a feel as to what they were actually, how these lies came out and what the impression given was as to their motivation? Your submission goes too far, doesn't it?
Well, Yeah, I mean, I fall back on the proposition I don't need to make the submission because they didn't make any finding. If they had made such a finding, then what one would have expected to find is here is lie, motive for lie X. You're trying to disguise the fact, which we find, that you have connections with Mogadishu. Their reasoning doesn't go down that line. So it is sufficient for my purpose to stop at the first part.
A lie could prevent your client proving his case if it simply left the tribunal completely uncertain, one way or another, as to the critical fact.
Yes, and rightly or wrongly, that's the explanation for for the divide between the minority and the majority in GM Eritrea. The other point of principle is if you simply don't know what the facts are, then even in an Article 3 case, the appellant or the applicant doesn't prove his case. But the whole ratio of the Court of Appeal in the present case is that we knew a lot more about my client, despite his evident lack of credibility. You know what? Those are the short opening comments. I propose to make 3 sets of submissions, effectively. First of all, to consider the evidence that was available about conditions in Somalia. That's fundamentally the country guidance case in AM. Your Lordships and my lady have seen that in some detail already, but if I can go to the relevant passages in my own way without reading them at great length, that would be helpful to me. Secondly, to consider the reasoning of the AIT in the present case. And thirdly, to go to the Court of Appeal and demonstrate what it was that they found was wrong with that reasoning. Can I say at once, I don't accept that they were simply finding that certain matters were left out of account. The core criticism is that they stopped short of evaluating the evidence and making findings which they could and should have made. Now, well, if we then go to the country guidance case, it's in volume 2 of the authorities bundle at tab 9. My learned friend took your lordship and the lady to paragraph 162 and 163, internal page 45 of the report. Lord, lady, can I just put down this marker? That description of the continuing relevance of the clan-based character of Somali society is written in the context of an assessment of the position in Somalia as a whole. It isn't Mogadishu specific, as your lordships will see from the comment in paragraph 166. Where they say that so far as the position of minority clans is concerned, neither party asked us to take a different view from that taken in HH, save in respect of their situation of civilians and or internally displaced persons. And then there's a note about Mogadishu, where they say, we go on to find below that the situation in Mogadishu for the great majority of residents is currently precarious. In our view, the situation of minority clans in Mogadishu will be a fortiori precarious. So what they're saying there, and we'll see this in more detail in a moment, is that whereas up until and including the country guidance case of AH, which was a 2007 case, there was an effective clan protection for the members of the majority clan in Mogadishu, the Hawaii. That had broken down by 2008, and we see this spelled out, and everybody, majority or minority, unless they belong to a very small subgroup, were in a precarious position, to use the language of 166. And then going on to the central passage, which the Lordships has seen, starts at page 171. Paragraph 171, did I say page? Paragraph 171, page 48. And paragraphs 171 and 172 describe the very extensive numbers of movements who have been fleeing the city, ending with the description at the end of paragraph 172 that Mogadishu is a ghost town and only the most vulnerable remain there. And then 173 recognises that there is some evidence that the more wealthy suburbs of the city have been safer, by and large, in the north. But in 174, they say at the end of that even this is changing. They say in 174, whereas the northern parts of the city, which are said to contain the most affluent districts, have been relatively unaffected, in January 2008, OCHA reported that IDPs were leaving Mogadishu, areas of Mogadishu hitherto considered safe, and then the examples are set out of various parts of Mogadishu in the north. And then 175 says that the violence is of a different character to what it has been, and is increasingly indiscriminate. And if we go on through to 177, contrary to the position with the Tribunal in H considered matters, where although there were large numbers of residents fleeing the city, there were also very significant numbers of returns. Since March 2008, the UN OCHA report showed there has been no large-scale return of IDPs to the city. And then your Lordships can see what's said in the second part of 177. And then 178, read together with 183, is very important to my case. And the tribunal say expressly, second sentence of 178, on the present evidence we consider that Mogadishu is no longer safe as a place to live for the great majority of its citizens. I stress that's majority and minority clans. Clans is irrelevant to that finding. Then we do not rule out that, notwithstanding the above, there may be certain individuals on the facts who may be considered to live safely in the city. For example, if they are likely to have close connections with powerful actors in Mogadishu, such as prominent businessmen or senior figures in the insurgency or in powerful criminal gangs. However, barring cases of this kind, we consider that in the case of persons found to come from Mogadishu who are returnees from the UK, they would face on return to live there a real risk of persecution and serious harm. So, my Lord, my other defence submissions are structured in part on the basis, as indeed is the tribunal decision, that there is a sort of undefined group of people who may be safe on return. In my submission, the only fair reading of this country guidance case is that you're going to need to be in a special position to be safe on return. The only examples anyone's ever come up with are those in 178. That is, you have close connections with powerful actors in Mogadishu, prominent businessmen, or senior figures in the insurgency or in powerful criminal gangs.
Was GM Eritrea decided 3 months earlier, actually cited to the
Yes.
AIT? It's not referred to, is it? Certainly not at this part. I mean, it cited in AM and AM.
Oh, sorry, cited in AM. Sorry, I'm getting confused. No, it wasn't cited in AM.
Yeah, but no. Because, their approach in 178 and 183, which you rely on, is actually inconsistent with the approach of the majority in GM Eritrea. if you rely upon it as showing that it is sufficient, simply to say, statistically, the great majority would be at real risk, therefore we can move straight to the question of viable internal relocation. That statistical approach is precisely what was rejected in GM Eritrea by the majority, particularly actually by Lord Justice Laws. He says general probability of illegal exit is not the point. You've got to look, the particular facts make all the difference. It's no good to show that statistically it's more probable. You've got to show this particular person fell within the minority or majority, as the case may be.
My submission, that's with respect to false dichotomy, because what in my submission this tribunal is doing in paragraph 184 is saying the fact that we can only find the very limited group of people in 178 who are likely to have sufficient protection on return, that is, people in the particular situation of close connections with prominent businessmen, well, powerful actors, let's use a shorthand, that's going to be enough to justify a finding of fact that you are at risk of a serious risk of return. Now, of course, if there's something in the case that suggests that you might have a connection with a powerful actor, then if you lie about it or you leave an evidential gap, then there's going to be difficulty. But it's not, both the way of fusing the approach of the Court of Appeal in my case, together with the approach of AM, is that there isn't a rule about this. It's simply a situation where you get the minority to be so unlikely, you are able to make fairly safe findings on the appropriate standard without further investigation.
Indeed, your first submission to the Court of Appeal was that the present is such a case.
Yeah.
And that submission was rejected.
Well, you need to be rather careful about that because it gets revived. It's recorded as part of the second submission.
Well, it is a bit odd, I agree. The fanciful point does seem to creep back, but your first submission was, on the face of it, roundly rejected by the Court of Appeal.
It was rejected because they said we know enough the tribunal were in a position to make positive findings even on the GM Eritrea approach, and I stand by it.
Why should that lead them to reject your first submission? That there might be an a fortiori case because there are specific facts which make it even more unlikely that your client would have any connection with these powerful figures.
Well, I don't think I can do more. Flash of honesty, I don't know why they rejected the first submission. It always seemed a rather better submission than they thought it was. They certainly, compatibly with the submission, felt able to go on and say, Mr. Drabble is right to say any contrary finding on these facts would be Wednesbury irrational. And I suppose what they're contemplating in the first submission, let's see what they actually say.
Paragraph 110.
Yeah, paragraph, indeed. I think they're saying that if you lie and all you know is, if you go back to paragraph 183 of AM, that you're from Mogadishu, say nothing more. Nothing about whether you're a majority, minority, clan, what the background is, and so on. Then you can't say it's merely it's fanciful. Not sure I accept the logic of that, but I think that's what they're saying. But then when you go on to consider the position of somebody who has all the characteristics of my client, then they do say there's only one conclusion that's open, and I urge that again.
The timing is really striking, isn't it? The decision in AM and AM, well, the hearing was in October 2008. And the decision comes down in 2008, and Senior Immigration Judge Perkins was party to that decision, although I think that Judge Story was probably its author. And here we have in December, that very same year, Senior Immigration Judge Perkins presiding over another case involving Somalia. He must have had all of that evidence that they had poured over in order to produce AM and AM very much in mind, mustn't they?
If the ladyship is simply putting, did he have it in mind, then the answer is transparently yes. If that means that the logical progress of, I think it's paragraph 109 and paragraph 121 and 122 of the second decision, not my decision, is logically correct, then my very firm submission is no. For the reasons that your ladyship already appreciates and which I'll spell out again. But I think I'm entitled to say it can't be a criticism of the decisions I now advance that I could possibly have succeeded on the fanciful route in the Court of Appeal. It's the bottom line, spell it out, is that my clan comes from a minority clan, almost of all of whose members will have left Mogadishu on the findings of fact by the time of the tribunal decision. His parents come from another part of Somalia, and he hasn't been anywhere in Somalia for 15 years. The relevance of that is that it's extraordinarily unlikely that he's been having conversations with powerful actors about, can you please arrange protection for me when I get off the aeroplane at Mogadishu? That is just, frankly, an incredible scenario. And as we'll see in a moment, it's not enough on the findings of the country guidance case to have connections with individuals in Mogadishu, as is expressly stated not to be enough to make you safe. You have to have connections with powerful actors. And in our submission, it was never, obviously, for obvious reasons, never put to my client by Mr. Giffing that he did have such connections. The thought is incredible. And no one believes he has such connections. And that's reality you at least need to bear in mind behind all this case, Right.
Part of the difficulty of this situation is presumably that he's got absolutely no incentive to make any inquiries at all at this stage.
No, but that's correct. I accept that. But equally, a fair reading of the decision in AM is that you would need to be in a very special position for such inquiries to be at all useful. I mean, it's...
Well, unless you know what contacts he has with family and with friends, you can't assess how useful they would be.
Well, I don't accept that because even, I'll show your lordship in a moment, the way this country guidance case dealt with one of the claimants in front of it, one of the appellants in front of it, was to assume, indeed positively find, that he or she had contacts in Mogadishu, but they were very unlikely to provide the protection of the sort that they are describing in 178 and 183. That comes back to my opening comments about what the lie might prove. I mean, supposing just for a moment against myself that the lie had been held to prove that there were contacts in Mogadishu, that on this country guidance case wouldn't get the Home Secretary home in terms of proving protection, because the breakdown has been so great that it's not enough just to have contacts or even to be a member of the majority clan. So, my Lord, my Lady, 183, obviously we say is an important paragraph. The court has seen it, and it goes together with paragraph 59 the Court of Appeal decision. Sorry, no, I think I've got the wrong, paragraph 95 of the Court of Appeal decision at page 30. Where the guidance is summarised in short, unless the individual is fortunate enough to be able to obtain protection by virtue of having close connections with powerful people in Mogadishu, he or she will face a real risk of persecution sufficient to engage Article 3. And in my submission, that's a fair summary of the country guidance case, and you do need a particular sort of set of connections in Mogadishu to be safe. Lord, if you then conclude my points on the country guidance case by asking the court to pick up paragraphs 18 and 19 of our printed case. I go to it in this form because I want to go to 20 and 21 as well, which make a particular submission. We set out in paragraph 18, paragraph 201 of the country guidance case, which does make it plain that at least the tribunal, the country guidance tribunal, is deliberately saying that in Article 3, cases, it will be enough to show that you come from Mogadishu, but if you're dealing with convention grounds, you will fail to show a convention ground for the risk to you unless you give a credible account of your circumstances in Mogadishu. That's what's been said in paragraph 201. And then your Lordship will see, if you go over the page to paragraph 208 of our case, we have set out paragraph 208 and this describes AM2's position in these terms. Although he's relatively young and able...
Sorry, I'm a little lost.
Paragraph 20 of our printed case.
20s.
20. My fault.
I see, yes, sorry.
Yeah. Particularly our paragraph 201 of the
Yes.
case with a comment on it. Although he's relatively young and able-bodied, we see nothing to indicate that he is someone who will be likely to have connections with powerful actors in Mogadishu, such as prominent businessmen or senior figures in the insurgency or in powerful criminal gangs. He had family members in the city at the time of the hearing of his case before Immigration Judge Begg in July 2007, but in view of the major displacement of the city's population since then, we think it unlikely that even if they are still there, they are any longer in a position to protect him as they did previously. So I repeat that even if there were a finding that my client had contacts in Mogadishu, that's not enough to show that he's likely to get protection, because the contacts need to be of a very particular sort.
You say at paragraph 19 of your case that AM2 had been the subject of largely adverse credibility findings. Had he denied having any contacts at all in Somalia, in Mogadishu? What was the nature of these adverse credibility findings?
I'll try and find out.
It seemed to be in the footnote.
Yes.
It was about past.
Yes.
Yes, and indeed, if we go back to paragraph 4 of AM, we might... I don't know if we can take it any further than appears on the face of paragraph 4.
It must depend on the nature of the adverse credibility findings.
I completely agree.
And here, the point that's made against you is that the adverse findings went very much to the heart of the issue, namely whether, or at any rate a part of it, namely whether your client had any connections at all. And he said he had no connections at all.
Yes, we're taking that at its worst against me, and one draws an inference that he does have connections in Mogadishu, which I certainly submit would be a wrong and indeed possibly a rational conclusion to draw. But even if one gets that far, one is not getting into a situation of showing that he is likely to have protection because of the nature of the displacement and the circumstances of a visit in Mogadishu. Mr. Denham points out that in paragraph 7, the tribunal in AM sets out some findings that it does accept, but I don't think that really helps us establish what they rejected. Just on this very quick reading, I'm trying to accept that it's not as specific as is said to be the case in my client's case. But for the reasons I've given, it doesn't take us any further. But going back to the approach the court, the Country Guidance Tribunal took to AM2, they did carry out an evaluation on the basis of the known facts to establish whether or not there was a real risk on return. We say there's absolutely no reason why the tribunal in the present case couldn't have carried out the same exercise. So, can I then move from the Country Guidance case to the AIT in the present case? And if the court will go to page 46 of the appendix. My learned friend took you to some passages from the earlier decision that the first decision in my client's favour had contained an error of law. And your lordship, and my lady, will see this in paragraph 4, besides the fact that the appellant came from Mogadishu, that his father, who was an Isaac, had worked there as a decorator before the Civil War, and that on the appellant's account given to Mr. Rory Mills, his parents were still in Somalia. I'm satisfied that the tribunal made a material error of law in failing to consider whether the appellant would be able to make arrangements for protection by the Hawaii through his connections with the Isaac. And then over the page, there's some discussion about the fact that the Isaacs have, at various stages in the history, had relationships which could mean they had protection because of their connections with the Hawaii. It's important to bear in mind that although my learned friend is entirely correct to say that is why reconsideration was ordered, by the time we get to the autumn of 2008, that perspective has disappeared because the major displacements have broken down that sort of possibility of protection. And your lordship can see that most readily from page 146 of the appendix, which is in volume 2. And within my last expert report And Dr. Hoyne sets out, about a third of the way down the page, the question, which I don't know if I correctly states, assumes as a premise that my client hadn't had any contact with anyone in Somalia since at least 1994, but the answer doesn't turn on that premise and reveals a very major change since reconsideration was ordered. As he says in paragraph 15, that the Foreign and Commonwealth Office statement seems, in my view, to blind out the decade of statelessness and civil war. In the early 1990s, scores of Somalis belonging to other than Hawaii clans fled from the fighting in Mogadishu. I was told that many more Daewoo than ISAC had to flee back. Then, at least more recent escalation of the civil war certainly affected a large number of residents in Mogadishu. March and April 2007, within about 4 weeks, between a couple of hundreds and 1,000 people, most civilian, died, and about 400,000 became refugees. The Human Rights Watch report on the fighting in Mogadishu, released in August 2007, amply documents the humanitarian law violations by all involved parties and the human suffering of thousands of civilians. More recently, as I stated above, almost 750,000 people are reported to have fled Mogadishu in the last 3 months. And he ends by saying, in my view, it's highly probable that also a considerable number of ISAC residents were among those refugees, more so since they, as non-Hawaii, cannot count on strong clan militia protection in the Hawaii-dominated environment of Mogadishu. Therefore, I consider it very unlikely that the same ISAC people who formed the ISAC community in 1994 will still form the core of that community now. So the background to both the country guidance case and the present tribunal decision is a recent and severe deterioration of the position of the ISACs in Mogadishu. And then we can go straight to paragraph 109, page 64. And paragraph 119 through to 121. And paragraph 109 says, the difficulty is that the appellant has not told us the truth about his links and circumstances in Mogadishu, and we cannot exclude the possibility as a person with connections of this kind. The point is that it is not fanciful to say he would not necessarily be at risk on return. Some people are not. Even though the appellant is only to prove a real risk rather than the probability of him being at risk, we cannot make the necessary findings when he will not tell the truth about his connections and contacts there. So the direction in paragraph 109 is not, we have examined the lie and we draw the inference that MA is lying in order to conceal connections which he does have with Mogadishu. The finding is that we cannot exclude the possibility that he's a connection, he is a person with connections of this kind, we cannot make the necessary findings when he will not tell the truth about his connections and contacts there. And the core of our case is that when one sits back and looks at what we do know about him, as the Court of Appeal set out, we'll come to that in a moment, it's obviously possible to make findings on even on a balance of possibilities, let alone the test that's been held to be appropriate to Article 3 cases by the Court of Appeal. I don't shy away from the proposition. It is possible to find, as on a balance of probabilities, that he does not have the requisite ability to get protection. Of course, there's a chance he has, but it's unlikely, very unlikely. And that perspective is even clearer if one goes on to paragraph 119, simply go straight. Well, the last sentence of 119 and then straight into 120 and 21. In 119, the tribunal say that the appellant is going to be at risk if we accept his evidence of having no contacts there. That's Mogadishu, as I understand it. We do not accept his evidence about that. He was manifestly untruthful, and we go on to say that they're perfectly happy to make that finding despite the delay which the fire caused at Field House. Paragraph 121, paragraph 178 of AM does not give an exclusive list of people who are not at risk. It makes the point that there are people who are not at risk. The burden is on the appellant, and he's not told the truth about his links. We are not able to say that he is a person who has shown he would be at risk there. Once again, that is not a finding, in my respectful submission, that he does have contacts with Mogadishu. It's saying they're not in a position to make the findings. And that is really reinforced by the last sentence. It would be very sad if by so doing the appellant has deprived himself of protection we'd otherwise need. So, in our submission, the undoubted fact is that the tribunal drew back from making the appropriate findings drew back from making any findings of fact. If there was an exact parallel with GM, and if GM is correctly decided, then it would no doubt be entitled to do that. But what it didn't do is what the Secretary of State says it did, which was to make a finding that my client did have contacts in Mogadishu and ascribe probative weight to the lie. That is no part of its reasoning. My Lord, if I can ask the court to look again at our printed case, that is what we say in paragraphs 44 and 45. No, well, I've got that's clearly the wrong reference. I don't know where that's come from.
Yeah, I think it would.
No, 44 is right.
That's because I'm looking at the wrong document. I'm causing myself immense confusion. It is 44 and 45. I'll come to geometric trail in a moment, but finally we do submit, as we read it, the position of all three members of the court, that if you, the applicant, have produced evidence that puts you in a vulnerable position, that may be or will be enough. What you can't do is simply rely on general statistical evidence arising from the fact that you belong to a class.
Would that itself not depend upon the nature of the statistical evidence?
Yeah. Well, I'm inclined to accept that. I mean, it seems to me that there's a danger I would accept of having a binary approach, that either it's general evidence or not general evidence. If it's general evidence, then that's not going to be good enough. And whereas if you've got beyond that, it may be good enough. What one has to do one would expect without the complication of the existence of GM Eritrea, is simply ask whether, on the information that's available, the court, the tribunal, can safely make a finding on the appropriate standard, be it balanced probabilities or be it MT Algeria, that there is a risk. And a very simple case is that there plainly was enough material applying that approach to find that there was a risk. Otherwise, one's giving a weight to the lie, which does disqualify one from making the appropriate findings.
In GM Eritrea, in addition to the statistical probability, they also relied upon the fact that it was a 19-year-old who was most unlikely to, or might be thought to be most unlikely to be a category of person which would get a legal exit. That wasn't regarded as sufficient by the majority.
No.
I mean, isn't it a question of factual judgment whether additional facts which you put into the equation tip the balance and create a real risk?
I think I would accept that, but that is not, as the Court of Appeal say, correctly in my view, what the AIT in our present case did. It didn't say, despite the following factors which point strongly in favour of a risk, nonetheless, there's a sufficiently large possibility that you are at risk to mean that you have not, sorry, you're not at risk, to mean that you haven't proved your case. That's not the mental exercise.
You didn't, I mean, it's been said that you didn't really draw attention to those factors. We were referred to your skeleton. Is that fair?
No, my submission is not the skeleton. Predates anything that the Secretary of State had said that was relevant to this issue at all. The skeleton was produced not by Mr. Giffin, but produced in advance of the hearing. And your Lordship has seen the paragraph in the skeleton which recites the fact that we thought there was no suggestion that my client was related to powerful actors. And that's how we approached it until the hearing developed. And certainly the submissions were made at the hearing that GM Eritrea could be distinguished because we knew enough to say that he would be at risk. As I recall it, my approach at the hearing was indeed to approach the matter on the basis that any suggestion that he was related to powerful actors was fanciful, to take the word from GM Eritrea. And that's a position that I stay with. So we're moving away from our printed case. Can I move to the second matter that I said I would deal with, which is the way the Court of Appeal approached it all? If your Lordships will go to Appendix 1, page 28. Lordships, and my lady again has seen a substantial amount of this. Page 30, paragraph 95, summarises the effect of the country guidance case. 96 through to 104 summarises the Court of Appeal's approach to GM, and I'll go to GM in a moment. I don't think I need to say anything about that. Indeed, I think I can go straight on to the summary of the grounds of appeal, which starts at page 34. And we've discussed paragraph 110 already. think I can sensibly add anything to that, to what I've said about that already. But then paragraph 111 is important because it does identify the approach that the Court of Appeal actually accepted. 111, they say, the second and more substantial ground was that the tribunal had misdirected themselves when considering the question of risk on return. They had wrongly applied the principles in the GM case. They had focused on the difficulties caused by the failure of the appellant to tell the truth, but they should have asked whether there was evidence related to the appellant's own particular situation, even ignoring his own rejected testimony, which would support his contention that there was a real risk that he would not have such protection on return. Now, pausing there, that is the submission I made to the Court of Appeal. In my submission, it's correct. And to answer Lord Phillips' most recent question, we say the proper approach is probably not to start asking questions about whether it's fanciful to say that the appellant wouldn't be at risk on return, but to simply ask the question whether, looking at all the material in the round, attaching whatever weight is appropriate to the circumstances of any lie to the lie, I've made submissions about that already, the appellant has discharged the burden of proof, however that is expressed. Once you have done that, there are sufficient factors here to support his contention that there was a real risk that my client would not have such protection on return. And your Lordship has seen that paragraph 112 summarises two alternative contentions. One is that the tribunal did not properly or adequately evaluate the evidence that showed there would be risk on return. Or alternatively, there's a Wednesbury submission, but if they did, they couldn't properly have reached the conclusion they did. And then paragraph 113 summarises the factors that we say are relevant. The evidence he relies upon, in particular the fact the appellant has been in the UK for some 15 years, and for almost all of the last 12 or so he has been in detention of one sort or another. In addition, his parents were from Hargeisa, not Mogadishu, and the evidence of Mr. Hono was to the effect that he would not get protection from the Ishaq clan in Mogadishu, given the dramatic evacuation from that city. And then there's a repetition of the fanciful submission. In the circumstances Mr. Drabble submits, it is fanciful to think that the appellant would be likely to fall into the exceptional category of persons with contacts in Mogadishu who could provide the requisite protection. All of that I repeat. And we do say that it is highly relevant, given the sort of connection that was necessary in order to provide protection, that my client had been away from Mogadishu for 15 years or so. Very unlikely to have continuing contacts with powerful actors. And then the Court of Appeal accept those submissions. Paragraph 117, they say, we think with respect to the tribunals, they're adopting the wrong approach. That's referring back to 109, which we've seen. The analysis suggests that the fact the appellant is relied has itself disabled them from reaching a conclusion on the Article 3 risk. And then there's the reference to throwing up their hands and a reference on to paragraph 121. So the finding is not that they didn't take into account the various factors that I relied on and which were set out in paragraph 113. But as a friend says, they must have taken them into account because they knew them all quite well, and indeed you can find them on the face of the tribunal decision. The submission is that they illegitimately regard themselves as disabled from making a finding of fact on the requisite standard because of the lie. And that is indeed what they say. Your Lordships will see that at the very end of paragraph 117 refers to 121, which one finds slightly further on in the appendix at page 67, where the reasoning of the tribunal is that he has stopped proper inquiry of a kind that might reveal the links and protection he would have. Now, if one thinks of the situation in GM, the approach of the Court of Appeal in GM is not that the inquiry has been stopped, but that once one realises one has no evidence at all about what the three individuals were doing between the time they left, between the time they were in armed service or as to the circumstances of departure.
I wonder whether the Court of Appeal did justice to what the tribunal said at paragraph 121. I appreciate that what they say at paragraph 109, but just focusing for the moment on 121, they place a lot of weight on the fact that the burden of proof is on the appellant. They say the burden is on the appellant, and he has not told the truth about his links with Mogadishu. And we're not able to say that he is a person who has shown he would be at risk there. And, just looking at that sentence, are they not there saying that because of his lies, we're not satisfied that he has discharged the burden of proof? And it's because of the lies that he hasn't discharged that burden. And the point comes again in the very last sentence. It does diminish his credibility and makes it harder for him to prove his case.
Yes.
So, although it's quite right to say that in paragraph 109, they say that we cannot make the necessary findings. I mean, reading the two paragraphs together, are they really doing more than saying, well, he has lied on something which goes to the heart of this issue? He hasn't discharged the burden of proof.
Well, first of all, I don't accept that characterisation. I mean, they do say in terms, even in paragraph 121, that he's stopped proper inquiry. I mean, that is part of the reasoning. He hasn't given them the help that they think he should have done in order for them to make the appropriate findings, stopped proper inquiry. But secondly, with respect to your Lordship's approach, if the tribunal was doing what your Lordship is suggesting it did do, then it would have done what Lord Justice Sedley said he would have expected, which is find some evaluation of those parts of the appellant's case which do strongly suggest he would be at risk, and then some explanation of why they do not, why despite that...
Well, I take your point about sort of a reasons point, if you like, lack of explanation of what they were doing. But I was merely questioning whether it's fair to say of paragraphs 109 and 121 that they were doing what the Court of Appeals said they were doing, namely throwing up their hands in despair and really effectively not grappling with the matter.
Well, it's to that last formulation that what the Lordship has just described as the reasons point goes, because it's not a reasons challenge. What it's saying is that one would expect, if the tribunal were grappling with the matter, to find some evaluation of the factors that are played heavily in favour of the contention that he would be at risk. So if there are two readings of 109 and 121, which I don't accept because in my submission they're crystal clear, then that absence of any further material is further evidence that what the tribunal has done is say we cannot make the appropriate findings. Because if they were doing it the other way, they would have to explain why, despite the fact all the Isaks have left Mogadishu and so on, we still find that he hasn't discharged the burden. And what is really notable on the facts is there's no explanation of why he shouldn't be at risk, other than the single sentence in paragraph 109. That they cannot exclude the possibility that he's a person with connections of this kind. In this factual context, where you need connections with powerful actors to be safe, one would expect some deeper and different analysis if one was going to be confident, we're going to reject the contention that what they've done is what the Court of Appeal say they've done. And, my Lord, my submission, that's exactly what the Court of Appeal are saying in the middle of paragraph 118, page 36. As they say in the middle of paragraph 118, nowhere does the tribunal say that the only potential evidence is the appellant's rejected testimony, and without it there is no relevant evidence. We do not think that it can be fairly inferred from their decision that this was how they approached the matter. And then there's the example of no reference at all to the fact that he hasn't been there for 15 years in the whole of the judgment.
Well, what does that sentence mean? Does it mean that the tribunal did take it into account?
The Court of Appeal is using it, the absence of reference to the 15 years, as an indication that they did not grapple with the issue whether the evidence that was left after you rejected the appellant's testimony was good enough in itself to discharge the burden. It's not a taking into account. Well, Leonard Frank characterises my case as certain factors being left out of account. That isn't the way we put it. It isn't what we say went wrong. What went wrong is that the tribunal did not, having rejected my client's testimony, go on to say, are the following matters sufficient to justify a finding that there was a risk?
But didn't the Court of Appeal say that the tribunal had not taken into account the detention period? Because in paragraph 120, we agree the tribunal ought to have made an assessment on the basis of that evidence, that is the lengthy period and the rest of it, and had they done so, they must have concluded. So they're saying that they didn't take it into account.
No, they're saying they didn't carry out the assessment. So I suppose that's a different way of saying they hadn't taken it into account.
Surely.
But it's not my case that they didn't know it. They plainly did know it. And plainly they knew he was a member of a minority clan and so on. Did they satisfactorily address the issue whether all of that was good enough? Then we say the answer is no. I mean, so in that sense, they left it out of account. I mean, you could describe it that way, but it's not a case where we say it wasn't in their minds at all, and it's not a case where my case is answered by the Secretary of State saying, well, it must have been in their minds. I mean, of course they knew he'd been in prison for a long time and had been in the UK for 15 years. Did they carry out the exercise that they should have done in the light of that? The answer is no. Then we come back to 109 and 121.
Well, that's isn't that a rather odd proposition, and not really how one usually approaches the decision of a fact-finding tribunal? If you accept that they had in mind this part of the testimony, it comes back to the point made a moment ago. Are you suggesting that they really went wrong in failing to spell out how they had it in mind? They themselves say they took account of all the evidence, and they recite that he'd been 10 years away from London and so on as part of the evidence, paragraph 85. It was unrealistic to think of him returning to Mogadishu after more than 10 years as returning to his home city. And then paragraph 88, we've considered the evidence in the round. You really say they didn't do that?
They did it in order to come to a decision which is structured in the way which 109 and 121 structures it. And that is to answer the question of whether he faced a real risk on return by solely referring to the fact that his account was not credible. You do not find in that part of the passage anything to suggest that they had looked at the inherent likelihood of him being at risk of return because of his membership of a minority clan, long absence from Mogadishu, and so on. There's nowhere in the operative reasoning of the tribunal do they address the question of whether or not it would be possible to make a finding of fact on those issues sufficient to discharge the burden of proof. They treat the lie as decisive.
But they've recited all of them. They've recited the enormous disruption and everything, and these are conclusions. He hasn't told us the truth about any links and circumstances, and we can't exclude the possibility there's a person with connections. That's a conclusion from everything that goes before. To say they should have repeated everything that went before once again there would have made that paragraph very long.
No, it wouldn't. I mean, all they would have
Paragraph
needed...
100, sorry to interrupt, but paragraph 108 is actually a conclusion in the opposite way around. We can't find positively that he's a person with close connections with powerful actors, so that's rather contrary to Miss Lang's submission.
Yeah.
But paragraph 109 is the other side of the coin. On the other hand, we can't find that he isn't.
Yeah, so on my approach, what one would expect to find, and what the Court of Appeal said they would have expected to find, is a paragraph that said, we recognise that the vast majority of individuals in Mogadishu will be at risk, see paragraph 183 of AM. We recognise that there are particular factors in this case that we have identified above, such as the fact that he is a member of a minority clan, has not been there for 15 years, and so on. That take him even beyond the generality of paragraph 183. But the lie has the consequence that we still find that he's not at risk because X. No, they don't do that, and I still don't know what the X is. And what I ask rhetorically is the role that they're placing on the lie if it isn't the one that I say it is, which is to exclude the possibility of fact-finding. It certainly isn't what Miss Lang says it is. Miss Lang says the lie is given weight, probative weight, to justify a finding that there were connections with Mogadishu. That isn't their thought
I think
process.
you've said that many times.
I have indeed. I'll always come back to something I can demonstrate to be correct. Yes. But yeah, that's the submission.
Yes.
Now, can I then go finally to GM Eritrea and 5 or 10 minutes? I'm going to sit down. Tab 17 of Authority Bundle 2. In my respectful submission, the factual position in GM Eritrea was very different, because it was obvious, it wasn't obvious because Lord Justice Buxton didn't find this, but the reasoning of the majority was to the effect that the absence of any credible evidence from MY did leave a range of possibilities which could not be excluded and which were real on the facts of the case. And the simplest way of demonstrating that that is the position is to ask the court to look at Lord Justice Dyson's judgment and in particular, for this point, paragraphs 63 and 64. And in our submission, it's possible to make a real distinction at each point in this judgment. My Lord says at paragraph 63, Firstly, even if the only category of 17-year-old girls who can leave Eritrea legally were students in the receipt of scholarships, I would be disposed to dismiss MY's appeal because there's no evidence of the percentage of girls in that age who fall into that category, and the judge made no relevant findings. Now let's just pause there. The contrast in the present case is that we do know from AM that it will be rare for anybody in Mogadishu to be safe. And the only category that anyone has ever identified of people who will be safe are people who have close connections with powerful actors. And we place some weight on the fact that neither the tribunal nor Miss Lang actually identify any other mechanism by which it could be said that my client was going to be safe. The only one that anyone has ever identified is the existence of close connections with powerful actors. So in our submission, stopping at the first sentence in paragraph 63, we're not in a position where there's no evidence of percentage of girls of that age who fall into the category and there are no relevant findings. So we have got the findings of the tribunal in MA. But then, my lord, went on to indicate that there were a range of other categories who might leave lawfully. And your lordship referred, very foot of the page, evidence obtained from the visa section of the British Embassy with a wide range of paid applications were made to the British Embassy for entry clearance to the United Kingdom. Not credible that these people would waste their money if they had not already obtained exit visas from the authorities. A significant number of these people were aged between the ages of 10 and 50. And then paragraph 64 says, nothing is known about MY except that she left Eritrea in December 2002 when she was 17 years of age. The burden on her was to show that there was a reasonable likelihood that her exit was illegal. In my judgment, she did not discharge this burden. And then he goes on to say, in the middle of the paragraph, in her case, as in theirs, as the two other individuals who lost in the Court of Appeal, any inquiry as to what she has been doing would be speculative. And in my judgment, once her account was rejected as incredible, the fact that she was female and 17 at the material time does not take her case out of the realm of speculation. She might have been a student in receipt of a scholarship, no evidence about the number of student scholars or the age at which scholarships were awarded. And that is to leave out of account the possibility that even if she was not a student, MY was one of a significant number of a wide range of paid applications from people between the ages of 10 and 50 referred to by the British Embassy. Entirely possible that MY left Eritrea legally. Now, my submission, unsurprisingly, we say we're not in that. There's no true parallel with that here. Second point on MY is just to emphasise that the case was, as Lord Justice Laws put it, paragraph 56 of the judgment, a stark one, in the sense that MY had given an account of leaving through the airport, which, if correct, the immigration judge had held would demonstrate that she had left lawfully. That would have destroyed her case. Otherwise, if she'd been believed, she would have had no case at all. And that is exactly what Lord Justice Laws says at the foot of page 13, is the first sentence of paragraph 57. Had the immigration judge actually found that she left through the airport, but legally, that would, of course, have been the end of her case. I'm not sure that's a legal difference, but it's a pretty stark difference on the facts in the present case. Not only was she not believed, but the account she gave would have destroyed her own case. Now, the final point that I want to make, without a great deal of analysis, is that the formulation that Lord Justice Laws put forward which in paragraph 53, is that the reason is that the probability that a particular person has left or not left illegally must depend on the particular facts of the case. Those facts may produce a conclusion quite different from that relating to illegal exit by members of a class of persons about whose particular circumstances, however, the court knows nothing more than their membership of the class. May indeed be a general probability of illegal exit by members of the class, but the particular facts make all the difference. That passage is an extension of what Lord Justice Law says in paragraph 50, where he refers to a real or substantial likelihood as opposed to a merely fanciful possibility. Now, in my submission, what has happened with GM Eritrea is that Lord Justice Law's judgment has been held to hold the meaning that the general evidence can only triumph even on a balance of probabilities if it is so solid as to admit only fanciful exceptions. That's what he puts it in paragraph 54. For our part, we don't understand why it needs to be put in that way. I go back to the submission I've already made, that one would expect the approach to be, look at all the evidence, look at it in the round, take account of the fact the appellant has lied, see what that does to the structure of his case, but if, at the end of the day, it's possible to say on a balance of probabilities that he's made out his case, then he has. The search for fanciful exceptions is just to create yet another test. And that's exactly what's happened in this case. The tribunal...
As I understand it, you don't accept Lord Justice Law's
not that formulation.
Too high.
Yes.
Right at the end. It cannot be done by general evidence unless the possibility that the particular facts may make a difference is effectively excluded.
Yes, I mean, we obviously up to this point have had to live with that formulation up until the Supreme Court, and we've been content to do that. But it does produce a false binary approach. Is the exception fanciful or not? In our submission, there's no reason why this question should be asked or answered in terms of fanciful exceptions. And my final submission is that, taking a step back, it is obviously far more likely than not that my client does not have access to protection of the sort described in AM in Mogadishu. And that's the heart of our case. Lord, those are my submissions.
Yes, thank you. Mr. Denon, anything you wish to add?
Lords, my lady, Mr. Drabble finished his submissions by saying that the heart of his client's case is that it's far more likely than not that his client does not have access to protection in Mogadishu than that he does. And that's precisely the statistical position that prevailed in GM Eritrea. Essentially, insofar as his criticisms of the AIT's decision are concerned, his criticisms were summarised, we say, when he submitted that really what was required of the AIT was a deeper and different analysis. Our submission is that the analysis that the AIT did go through was adequate and lawful, and to require the deeper and different analysis which his submissions would impose on a fact-finding tribunal is just a step too far. The thrust of GM Eritrea, the majority decision in GM Eritrea in our submission, is not to require that deeper and different analysis where an appellant has lied on an issue which is important to the establishment of his claim to international protection. On analysis, his criticisms of the AIT's decision are really criticisms about the weight that the AIT attributed to the factors on which he relied. But as I said, as I submitted this morning, matters of weight are essentially matters for the tribunal, and what is mentioned expressly in the tribunal's decision may well be a guide to the matters which were given weight by the tribunal. We rely on the passage from Lord Justice Elias's decision in TM Zimbabwe, which I won't read now, but it's paragraph 112 of our printed case in this regard. He submitted that in this case there were sufficient factors to show that there would be a risk on return. But our position is that for him to succeed on an appeal on a point of law, it's not adequate to submit that there were sufficient factors here to show there was a risk on return. It's only the position that an appeal should succeed if the factors pointed in one direction and in one direction only. And the key point, which I would make again, is that on the basis of his expert's evidence, as summarised in the AIT's determination, the possibility of protection for someone in this position is not excluded. He submitted that if the evidence in a case puts a person in a vulnerable class, that may be enough to enable their claim for protection to succeed, and we would agree with that formulation. However, we would go further and say that whether that is enough will depend on other material in the evidence, for example, whether or not the appellant has told a relevant lie. And if an appellant has told a relevant lie, then that may well affect the tribunal's assessment of whether the mere fact that they're in the vulnerable class is enough to enable their claim to succeed. That's the approach that the AIT adopted here, and we say that it's an approach that they were lawfully entitled to adopt. If I can just deal with the position about what flows from the rejection of evidence by the AIT. The fact that the AIT rejects evidence may simply give rise to a lacuna or a gap in the evidence, but there will be circumstances where the rejection of evidence could amount to a positive finding, and it all depends on the reason why the evidence has been rejected. Now, in this case, the respondent made a positive claim not to have any contacts in Mogadishu. That was his case. And it was that part of his evidence which was disbelieved by the AIT. That's the passage connecting paragraphs 119 to 120. This appellant is going to be at risk if we accept his evidence of having no contacts there. We do not accept his evidence about that. Now, paragraph 108, to which my Lord Mance referred, doesn't with respect contradict that submission, because what the tribunal are saying in paragraph 108 is that they're not able positively to find that the appellant is a person with close connections with powerful actors in Mogadishu, and so on. So they are aware that there is a distinction, and they're drawing a distinction between, on the one hand, a person who has contacts in Mogadishu, and on the other hand, a person who has close connections with powerful actors. And the point about the lie, the effect of the lie in this case, we submit on the tribunal's analysis, is firstly, they didn't believe the lie and they found that he had contacts, but the lie disabled them from making any assessment of the nature of those contacts. In other words, whether they were contacts with powerful actors and so on. And so the tribunal is not throwing up its hands and refusing to make findings about risk. What it's saying is, we find he has contacts, but his lies prevent us from evaluating the nature of those contacts. We can't make a positive finding, we can't fill the gap by making a speculative finding that he has contacts with powerful actors. And on the basis of, I think it's the fifth proposition which we draw from GM Eritrea, the tribunal is not obliged to fill an evidential gap by making speculative findings. And So the position here is that on our submission, they're finding he did have contacts, but the lie prevented them from evaluating the nature of the contacts. The general evidence and the expert evidence was such that if you had contact, it couldn't be excluded that you could get protection. And we say that is enough to show that the AIT's analysis was open to them and a lawful analysis. Just two very short points arising from the submissions that Mr. Drabble made in opening. The first is just to say again that there is an important difference between this case and the case of AM2. The difference is that in the case of AM2, in the country guidance case, AM and AM, no up-to-date assessment of the possibility of protection was made by the tribunal. So in other words, the tribunal was asked to hear up-to-date evidence from the appellant, and they refused that application. The tribunal was content to deal with matters on the basis of earlier findings made by the earlier tribunal. And it's important to emphasise that the adverse credibility findings that had been made by the earlier tribunal solely concerned AM2's account of his earlier experiences in Somalia. They had absolutely nothing to do with the availability of protection or otherwise. Insofar as my learned friend Mr. Drabble relies on paragraphs 183 and 201 of AM and AM as apparently enunciating some sort of rule of law, that if a person is from Mogadishu, then their claim should succeed. I'm summarising slightly. We say if that's what the tribunal and AM were doing, it was something they couldn't do, and it was quite wrong. Can I just have a moment? Unless there are any further points on which I can assist, those are my submissions.
No, thank you very much. The court is grateful to counsel for their submissions and will reserve its judgment.